What unfolded was not a routine court development or another predictable chapter in a long-running legal saga. It was a sudden judicial rupture that appeared to come out of nowhere, leaving Donald Trump and those around him scrambling to understand how the ground had shifted so dramatically beneath their feet. Legal analysts immediately began describing the moment as historic, not because it added yet another case to an already crowded docket, but because it revealed an entirely hidden dimension of legal exposure that had been operating in silence for more than a year. At the center of this shockwave was a Supreme Court order compelling Trump to turn over a sweeping range of financial records, internal business communications, and sensitive documents without delay. The decision did not follow the familiar rhythm of public arguments, advance notice, or media briefings. Instead, it surfaced abruptly, exposing the existence of a sealed grand jury investigation that had progressed through the federal court system largely unseen. Even Trump's own legal team, by several accounts, did not fully grasp the scope or trajectory of this proceeding until the order became unavoidable. What makes this development so extraordinary is not merely the involvement of the Supreme Court, but the manner in which the case was handled. The court almost never operates in total secrecy. Its docket is typically transparent, its schedules announced well in advance, and its reasoning dissected in real time by the press, scholars, and the public. Yet the judiciary retains a narrow and rarely used authority to conduct sealed proceedings when disclosure itself could cause serious harm, particularly in matters touching national security or similarly grave interests. That authority was invoked here, and the implications of that choice are profound. According to the order, the sealed process began more than a year earlier, when a federal grand jury issued a subpoena demanding extensive documentation connected to Trump's business and political activities. Because the subpoena was sealed, Trump was notified under strict confidentiality rules. He and his attorneys were legally barred from acknowledging the subpoena's existence or discussing it publicly. The legal fight that followed unfolded entirely behind closed doors, with filings, rulings, and appeals shielded from public view. Trump challenged the subpoena using arguments that have become familiar in his public cases, including claims of executive privilege and presidential immunity. In this instance, those arguments failed repeatedly. A lower federal court rejected them. An appellate court followed suit. Finally, the matter reached the Supreme Court, which issued a definitive ruling ordering immediate compliance. In doing so, the court effectively revealed for the first time that this hidden battle had been taking place at all. The opinion attributed to the Chief Justice left little room for ambiguity. It concluded that the materials sought by prosecutors concerned conduct that fell outside any plausible claim of presidential immunity. It also emphasized that efforts to delay compliance had already been fully exhausted within the judicial system. No further extensions would be granted. The court's language was firm, direct, and unusually blunt, signaling that patience had run out. Legal observers quickly noted that this investigation appears to be separate from the criminal cases already known to the public. It does not merge with the classified documents prosecution, the January 6 related charges, or the election interference case in Georgia. Instead, it represents a distinct legal front, one that developed without public awareness and now stands poised to reshape assessments of Trump's overall legal risk. This element of surprise is what distinguishes the moment from prior defeats Trump has suffered in court. In earlier cases, unfavorable outcomes were often anticipated months in advance. His legal team had time to plan responses, adjust strategies, and prepare public messaging. Even landmark rulings involving past presidents unfolded after prolonged public litigation. Here, by contrast, the realization arrived all at once. Trump began the day believing he understood the universe of threats he faced, and ended it discovering that assumption was fundamentally flawed. Reports described frantic activity among Trump's attorneys as they tried to determine what exactly the subpoena covered and how quickly compliance would be required. The order set a deadline of 72 hours, not weeks, not months, 3 days. The court further warned that failure to comply fully and in good faith could trigger immediate contempt proceedings, including potential detention. Such language is exceedingly rare and underscores the seriousness with which the judiciary views the matter. This left Trump with no familiar escape routes. There is no higher court to appeal to, no procedural maneuver left to buy time. The decision is final. Compliance is mandatory. Any attempt to stall, defy, or partially comply risks swift consequences. Attention then turned to the scope of the materials being demanded. The subpoena seeks 3 broad categories of evidence. First, it requires comprehensive financial records dating back to 2015, including transactions involving foreign entities, loan agreements, and communications related to property valuations. The breadth of this request suggests prosecutors are not examining isolated incidents, but looking for patterns that could indicate systemic misconduct. Second, the subpoena demands communications between Trump and specific foreign individuals whose identities remain redacted due to national security concerns. This element goes well beyond ordinary business dealings and has fueled speculation about possible interactions with foreign officials or figures linked to intelligence services. The decision to keep these names sealed indicates sensitivities that extend beyond typical criminal investigations. The third category may be the most consequential. Prosecutors are seeking documents related to efforts to obtain items of value from foreign sources in connection with electoral activity. That phrasing closely mirrors federal statutes prohibiting foreign contributions to U.S. campaigns. Its inclusion strongly implies investigators are examining whether such prohibitions were violated. For Trump's defense, the logistical challenge alone is immense. Producing nearly a decade's worth of complex financial and political records within 72 hours borders on the impossible. The risk, however, is not merely logistical. Whatever information Trump fought to keep hidden throughout a year of sealed litigation is now on the brink of disclosure to prosecutors who have already demonstrated they know precisely what they are looking for. Accounts of Trump's reaction describe anger and disbelief, with blame directed at his legal team despite their inability to speak openly about the case due to confidentiality constraints. The secrecy that once served as a shield ultimately deprived Trump of a key advantage: the ability to rally public support against a process no one knew existed. Public statements attacking the judiciary followed quickly, raising additional concerns among legal experts. Openly declaring an intent to defy a Supreme Court order can itself become evidence of willful noncompliance. If prosecutors move forward with contempt proceedings, such statements could significantly strengthen their case. This situation presents Trump with a stark dilemma. Compliance could expose new areas of criminal liability, potentially more serious than those already known. Defiance could result in immediate sanctions, including incarceration, independent of the underlying allegations. Attempts to delay appear futile given the explicit terms of the order. Beyond Trump himself, the revelation of this sealed investigation has unsettled his allies. If one confidential case advanced all the way to the Supreme Court without public notice, it raises the possibility that other undisclosed inquiries could also be underway. Defense strategies built around known cases may now appear dangerously incomplete. The strain is reportedly extending to Trump's legal team, with some attorneys reconsidering their involvement amid concerns about undisclosed risks and ethical exposure. Any withdrawals at this stage would only compound the chaos, as new counsel would have no time to catch up before critical deadlines expire. Meanwhile, cooperation from former insiders adds another layer of danger. Individuals familiar with Trump's records and conversations are said to have provided investigators with detailed guidance about what exists and what efforts were made to conceal it. This allows prosecutors to quickly identify omissions or inconsistencies in whatever Trump ultimately produces. Taken together, the elements of this investigation suggest a scope that reaches beyond previous cases. The focus on foreign financial ties, sensitive communications, and electoral conduct points toward potential violations that strike at the intersection of money, power, and national security. Scholars have already begun comparing the moment to the most consequential confrontations between the judiciary and the presidency in modern history. What this means going forward extends beyond one individual. The court's action reinforces the principle that former presidents are not shielded from confidential judicial scrutiny when alleged conduct falls outside official duties. It also demonstrates that secrecy, when justified, can be used not to protect power but to prevent interference and delay. Whether the full contents of these records ever become public remains uncertain. Some information may remain classified or be introduced only in tightly controlled legal settings. Even so, the consequences of their review will likely emerge through charges, rulings, and courtroom revelations. This moment marks a turning point not just in Trump's legal narrative but in how accountability at the highest levels of government is understood. The era in which public spectacle and procedural delay could reliably blunt judicial action appears to be narrowing. What happens next will depend on choices made under extraordinary pressure, with outcomes that could reshape both legal precedent and political history.